Hi there. Welcome to Help Solve the Case. I'm Christine. If you don't know me, retired police detective and sergeant, law enforcement expert, forensic genetic genealogist, and investigator. And I love everything courts and trials and criminal justice. And I really love you guys. We are getting really close to the thousand, say that 10 times fast, the 1,000 subscriber mark. And I really, really appreciated all your great comments. Thank you. Thank you so much for supporting my mission. Today we are here. We are following up on the Karmelo Anthony trial. He was convicted, as you may know, if you're following it, and we have a motion for a new trial. So we're going to get into that today. And I wanted to share that I put all the documents and the cases in the Help Solve the Case bullpen, which you can become a member if you would like. I will put the link below the video, but we're going to go ahead and look at that today. So let me fix my little layout here, hopefully, so you guys can see me pretty well. Okay. And let's talk about it. All right. So this was filed July 7th, 2026 in Collin County. And it is a motion for new trial and brief in support. And it is a long one. It is 193 pages. Okay, so we'll see what we can do here. Now, he's talking about pursuant to the rules of the Texas Rules of Appellate Procedure, moves the court to set aside the judgment of conviction and sentence and grant a new trial. They're saying it is 4 grounds. First, the court committed structural error when it materially restricted public access in violation of the right to a public trial. Okay, publicity, very important. We're seeing a lot of back and forth if you're following my coverage of the Charlie Kirk, Tyler Robinson case. Oh my goodness, right? A lot on that. We even have attorneys for the media and attorneys for the victim pushing for transparency and publication. Okay, so that's the first count. Second, the state's repudiation, right? Semantics, we love our words here, of the parties' unrecorded evidentiary agreement after the defense relied on it, coerced the waiver of Mr. Anthony's right to testify and denied him a complete defense in violation of his constitutional rights. That's a huge sentence there. Let me see what that is. So it sounds like there was some sort of agreement that the defense relied on with a waiver of Mr. Anthony's right to testify, which denied him a complete defense. Or there was something said that then limited him testifying. We're going to get into that. I'm not sure what that is. Third, the trial court improperly instructed the jury on applicable law. Okay. And fourth, the cumulative effect of these errors warrants a new trial in the interest of justice. So that fourth count, if we're going to call it that, I'm not sure if there's a rule or a precedent that says something about the cumulative effect, right? Because it doesn't, it's just saying that everything together warrants a new trial. Okay. So it says this case presents a structural public trial violation. Okay. When they're talking about structural, again, I'm not an attorney. I don't know. I'm just trying to interpret this like you guys are. I started out as a paralegal way, way, way back in the day. Not that I'm better at legalese than you guys, but I'm going to do my best here. So usually when they talk about structural, I'm thinking foundational, and we hear foundation a lot when it talks about challenges and things like that. So the word structural here means like a foundational, pillar of, right? It has to be there. Okay. We think about structure of a building or foundation of a house. It says the court, okay, and that means the court, the judge, the court had authority to manage courtroom security, decorum, and capacity. But once it adopted and administered restrictions that foreseeably excluded members of the public from a high-profile criminal trial, it was required to make record-supported findings and to consider reasonable alternatives to closure. Not sure where they're going there. The court did neither. The access regime limited public attendance to a narrow daily admission period. I did hear something about that, very small, with regards to at least the media and stuff. And no continuing overflow or audio or video access after jury selection. Because that closure affected the trial proceedings themselves, and for the 3 additional grounds set out in this motion, defendant asked the court to set aside judgment and grant a new trial. In support, defendant shows the following. The case, getting into the factual background, the case and the verdict. This case arises from an altercation at a high school track meet. The defendant, Karmelo Sincere Anthony, was charged by indictment with the murder of Austin Metcalf, alleged to have been committed on or about April 2nd, 2025 in Collin County, Texas. The defendant pleaded not guilty. His defense at trial was self-defense, that he used force he reasonably believed immediately necessary to protect himself. Let me talk about that. If you want to go back and watch my videos on that, okay? I was very surprised at the immediate arrest, given what was transpiring on scene that I was aware of, okay? In my cop perspective, okay? Right? I look at these cases, if you don't know, I look at them from all different perspectives. Okay, he used force reasonably believed immediately necessary to protect himself. The court's charge submitted the offense of murder, the lesser included offense of murder, and the law of self-defense, including the justified use of deadly force. The defendant did not testify. So it sounds like that the jury was charged with the information of murder, manslaughter, self-defense laws, and the justified use of deadly force information. Okay, that's what it sounds like. They had that. On June 9th, 2026, the jury found the defendant guilty of murder, and the court imposed a sentence of 35 years confinement. These matters appear from the indictment, the court's written charge, and the judgment. Okay, they talk about charging the jury. So I think that's what they're referring to here. Of course, we weren't there. We didn't hear it, so we don't know. We were just, getting snippets. The case drew national attention from the outset, and the court appointed a public information officer to assist with media credentialing, communications, and access logistics. In practice, public and media access were administered through that process. They have Exhibit 1 and Exhibit 7, which we'll probably get to. What follows is how that access was in fact administered: before trial, at the perimeter of the courthouse campus, at the courtroom door, and after the verdict. Okay, here's a big word: secrecy before trial, the gag order, chambers conferences, and no public pretrial hearing. The closing of this prosecution to public view began more than 10 months before trial. On July 28, 2025, acting sua sponte and on no party's motion, the court entered an order prohibiting extrajudicial statements. Okay, so what they're saying, I don't know what the sua sponte is, but on no party's motion, so nobody asked for it. The judge just did it according to what they're saying. A gag order binding the parties and their attorneys, witnesses, law enforcement personnel, courthouse and court staff, and court-appointed officials, which by its terms remained in force through trial. They are referencing it to Exhibit 1 and Exhibit 2. Covered persons with firsthand knowledge were restricted from speaking publicly about the facts, evidence, witnesses, and expected testimony absent written approval from the court. The gag order's terms were sweeping. It's a big word too, right? Sweeping. Unless, quote, first approved in writing by the court, end quote, no covered person could make any extrajudicial statement that, quote, addresses the character, credibility, expected testimony, guilt, or innocence of any party or witness, end quote, that, quote, discusses evidence anticipated to be introduced at trial, end quote, or, quote, that intends or is likely to influence public opinion or potential jurors, end quote. Restrictions, excuse me. I've got morning voice. You're the first folks that I've spoken to this morning. Okay. Um, so they said that, you know, anything, saying anything that intends or is likely to influence public opinion or potential jurors. Restrictions expressly applicable to, quote, any public medium, including traditional news outlets and social media, end quote, and enforceable by, quote, contempt, fines, attorney discipline, or other remedies, end quote. And they talk about Exhibit 1. Its findings were 3 sentences. That media coverage, quote, has the potential to cause imminent and irreparable harm to the defendant's right to a fair trial, end quote. That, quote, alternative measures, such as a venue change, juror screening, sequestration, would be inadequate alone, end quote. And that, quote, narrowly applied speech restrictions are necessary to protect juror impartiality, end quote. Okay, that's what the judge gave as the reasons in the order. It says here, this pleading from the defense says, no evidence is recited. The order permitted only, quote, procedural announcements, for example, hearing schedules, court filings, end quote, and statements required by legal or ethical duty, a safe harbor that presupposed filings the public could see. By its terms, it would yield only to, quote, further written order of this court, end quote, and the amended order later reaffirmed it, quote, until the completion of the trial, end quote. So it sounds like they had an order and then they had an amended order. In the 10 months it operated, no person was ever alleged to have violated it, so as far as the public record reflects. And they're referring to the exhibits again. The substantive pretrial work of the case was then conducted out of the public view. And again, I'll reference Charlie Kirk hearing, that the preliminary hearing is wide open. They're going back and forth and arguing Supreme Court precedent and state precedent, and the media is there talking about the public's right to be present at this trial. So maybe some of those cases that they're talking there, I don't know. I've never really got into this issue about what we should be able to see and what we shouldn't be able to see. The ones that I've been involved in, I've been participating in, okay? So this is very interesting, right? Who do we, as a public, what do we have a right to see? Okay. The parties' pretrial conferences with the court, including a May 21st, 2026 conference in chambers, at which the parties' evidentiary understanding was described to the court, and a May 29, 2026 meeting addressing trial security and scheduling occurred in chambers outside open court. So how I'm reading this is that they had a pretrial conference, and what they're talking about, their evidentiary understanding, is what evidence they were going to put on at trial. Prior to trial, you have to provide the court with your exhibits and what you're going to talk about, okay? What you're going to present based on what's been allowed, okay? Because, you know, there's limitations, right? A lot of times we hear the jury says, I didn't see that, I didn't know that, okay? So all that goes on up to trial, and then trial, they go back and forth about things being admitted, okay? It says, no reporter's record of them exists, a matter the hearing will confirm. So, is it in the court record or is it not in the court record? It says no reporter's record of them exists. I'm assuming, well, I don't want to assume, but I'm believing they're referring to a court reporter, not a media reporter. Typically, these things, well, it was in chambers, so they may not have anything. No pretrial hearing was ever held on the access restrictions, and the register of actions, that might be the court record, I'm not sure, reflects no such setting. The public docket discloses no motions in limine. Okay, they usually do those right up until the time, what we're going to do and how we're going to do it. And none of the substantive pretrial litigation that in fact occurred, filings that were hand-delivered rather than filed in the district court's public record. Doesn't seem like a whole sentence. The public docket discloses no motions in limine and none of the substantive pretrial litigation that in fact occurred. Filings that were okay. A member of the public who examined the docket before trial would have found no hearing to attend and nothing to read. Okay, so they're saying that there were discussions and pleadings that happened, all the stuff that happened, and nobody would be aware of it because it wasn't on the docket. It wasn't on the district clerk's public record. Okay, now they're going to talk about this amended order. On May 18th, 2026, the court signed the amended order regulating trial proceedings, media access, security, and courtroom decorum, entered, quote, to govern all aspects of the trial proceedings, end quote. The order recited the directives of Waller v. Georgia and Shepard v. Maxwell. Okay, so those are case citations, and found that, quote, unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial, end quote. Now, I don't know if they've been quoting Waller in Kirk or not. I'm not sure if I've heard Shepard v. Maxwell. So Waller v. Georgia is probably, unless somebody's named Georgia, probably a Georgia case. Shepard v. Maxwell, I don't know what that is. Might be a civil case, not sure. And promised, well, if there's a defendant, excuse me, if there's a defendant, it's got to be a criminal trial, so not sure. And it promised, quote, reasonable public access consistent with constitutional requirements, end quote. They're talking about this amended order, promised, quote, reasonable public access consistent with constitutional requirements, end quote. Its operative terms were these. The courtroom would open at 8:30 for the media, 8:40 a.m. for designated family members, and at 8:50 for the general public. No more than 9 members of the media would be admitted. Seating would be on a, quote, space available basis, end quote. The doors would would close promptly at 9 a.m. Individuals arriving after that time would not be admitted until a recess. No person who left could re-enter except at a recess. All persons attending were required to dress in, quote, appropriate business attire, end quote. Hats and caps were prohibited, and clothing or items, quote, displaying messages, logos, symbols, or images related to the case, end quote, or, quote, otherwise distracting or potentially prejudicial, end quote, were banned. Now, we have heard some of that in the Charlie Kirk case. And the reason I'm mentioning the Charlie Kirk, Tyler Robinson case is because there's a media attorney there who gets up and talks pretty frequently, okay, about the media's rights. So maybe we'll get some information there. All right. The order appointed Steve Stoller, identified in the order only by a personal email address and cell phone number, as the court-appointed public information officer. It's weird that he would use his personal email address. Committed media credentialing to that office and announced, quote, that the court will not intervene in or resolve disputes among members of the media regarding access or seating, end quote. So it sounds like this guy was, it says he's the court-appointed public information officer, but he was doing the media credentialing. The order contained no provision for an overflow room, an audio feed, a video feed, or any other means of observation for members of the public turned away, and no mechanism by which a member of the public could be heard to object to any of it. And that's an interesting statement. What would the public be objecting to? Do we, I'm not an attorney, do we as members of the public have the right to intervene, right? So this media lawyer, he just walks up, right? He starts talking to the judge in the Kirk case. He just starts walking up and talking to the judge. So maybe we as the public, if we have any counsel here, maybe we have a right to, I don't know how we would get in or raise our hand. I don't know. I've never seen that. Okay. The order also closed the courthouse grounds themselves. It placed the entire courthouse campus, quote, including parking lots, sidewalks, green space, or any other designated area, end quote, to a nightly curfew from 11 p.m. to 6 a.m. beginning May 31st, 2026. It designated restricted zones on an attached exterior map, and it ordered the Collin County Sheriff's Office and other law enforcement personnel, quote, to ensure compliance with this order at all times during the trial, end quote. Under the order's enforcement clause, any violation, including a citizen's presence in a courthouse parking lot or on the green space besides the courthouse before 6 a.m., expose the violator to, quote, immediate removal from the courtroom, courthouse, or courthouse grounds, end quote, and, quote, the imposition of sanctions, including contempt of court, end quote, and, quote, no warning is required prior to enforcement, end quote. No findings of any kind accompanied the curfew, right? So no findings. Why a curfew? And excuse me, guys, I did hear that people were arrested, but I don't know if it was disorderly conduct or was in violation of this order or what. So I'm not sure. I think this was, I don't know if it was during the trial or was after the trial. Okay. Now they're talking about access in operation, the curfew of the parking lot, and the pre-dawn line. In operation, admission to the courtroom, I believe, maybe not. In operation, admission had almost nothing to do with the order stated 8:50 a.m. public entry time. Because the public seats were few, I think I know where they're going here. If you can't get into the parking lot, you can't line up, therefore you can't get in. Maybe that's where they're going, right? I mean, think about Christmas at Walmart, okay? Like when people line up for specials, okay? I think that might be where they're going. In operation, admission had almost nothing to do with the order stated 8:50 a.m. public entry time. Because the public seats were few, members of the public began arriving in the pre-dawn hours, often between 4 and 5 a.m., before the court was in session and while the campus curfew was still in force, and sheriff's deputies enforcing the order stopped arrivals at the parking lot and restricted entry onto the campus until the curfew lifted at 6 a.m. The queue that actually determined who would see this trial thus formed at the perimeter of the courthouse campus hours before any proceeding convened. A member of the public who appeared at the order's appointed hour of 8:50 a.m. had, as a practical matter, no prospect of a seat. That's an interesting look at it, right? So if it tells you it's open to the public at 8:50, you can come in at 8:50 and they've been lining up since 4 or 5, you're not going to get in, right? The line itself was administered without published standards and not even-handedly. Individuals were permitted to move ahead of members of the public who had already waited for hours. Thelma Anderson, who arrived early on June 6th and initially held approximately the 7th position, was displaced to approximately 35th beyond the number of available seats and was excluded from that morning's proceedings. And they got an exhibit there, 18. Demetra Carter, identified as number 7 on an early arrival list, okay, they have a list, right? They're given actual details here, was removed from the line on June 5th and lost the morning session, exhibit 15. I don't know what that's all about. Admission was run through 2 lines, one for a, quote, media list, end quote, and one for, quote, everyone else, end quote, exhibit 16. And media outlets denied credentials were directed by the public information officer to seek entry through the public line. Oh my goodness. Were they moving the media, the uncredentialed media ahead of the public? Let's see. Where, as a Collin County Sheriff's deputy administering the line, acknowledged on video, persons who, quote, print out whatever and make themselves like they are media, end quote, consumed the public's few seats, a practice the officers conceded they could not police. Oh my goodness. Okay. Inside the courtroom, 24 public seats and an overflow room provided and then withdrawn. The courtroom held approximately 70 seats. By the court-appointed public information officer's own written account, 15 were allotted to the prosecution's family, 15 to the defense's family, and 9 to the media, including a courtroom sketch artist, with additional seats for court staff, leaving, quote, about 24 or so seats for the general public, end quote. The trial judge later confirmed the arithmetic on television, some, quote, 200 requests by the media, end quote, and, quote, 27 to 32, public seats, that we rotated every day, end quote. None of these allocations appear in any order, and the 15-seat family allotment was not honored in practice. The defendant's own family was limited to 8 seats in total, so that his grandfather and his aunts were excluded from his trial, while those admitted were required to register a day in advance and were warned that a visible facial expression could result in removal. Okay. I am going to stop here because I'm getting ready to start watching Charlie Kirk. This is big. I'm going to continue going through this. I'm going to do it in parts and pieces like I normally do. Let me know what your questions are. I will work on these and I will release them little by little because I think this is important. I had no idea that all this was going on. And so I will do that in parts. I'm going to cut this one off and then I will continue with the rest of them. I really appreciate you being here. Thank you for the likes, the shares, and the comments. And I will see you on the next video.